Super Bowl of lawyering, and it is an incredibly rare feat. The court receives about 10,000 cert petitions a year, and this term it agreed to hear about 80 cases. When you think about the cases that beat those odds, I think it's pretty safe to say that family law would not be at the top of your list. But today's speaker did just that. Mike Maneely is the founder of the Maneely firm, a 10-lawyer family law practice based in Marietta. And this term, not only did the court agree to hear his case, an international child custody matter, but despite an army of would-be poachers, I'm sure, he argued the case himself and won in a unanimous opinion. So here to share with us that extraordinary story, please welcome Mike Maneely.
Get this turned on. Thank you very much for having me. It is an honor to have an opportunity to speak in front of the folks that I revere, do all of the hard, heavy lifting of creating the laws. It's one thing to be trying cases, but it's another thing to be doing the work that results in the opinions that lead us all forward and tell us how we're supposed to operate. To begin with, I want to let you know that all of this is not my fault, it's actually Lynn's fault. Lynn is the one that, I petitioned the Supreme Court once before on Furness versus Reeves. Lynn is the one that moved for my admission to the United States Supreme Court. And her name's on my wall in my office in Marietta, right there on that admission certificate, so it's all Lynn's fault. To begin with, you all may have heard of the Hague Convention. It's gotten a lot of press lately. We call it the Hague Convention in family law parlance. There are a lot of different Hague Conventions, but in family law, when we're talking about that, we're talking about the one that has to do with missing children, abducted children, inter-country removal by one parent, usually to another country where they just take off and leave and don't come back. We have almost 90 nations that have agreed to abide by the convention, and it is, if you think about the UCCJEA, it's like that. It's a jurisdictional test. There's some exceptions to it, but really it's a jurisdictional test. And where that comes from is that prior to, and the reason for the Hague existing in the first place, was home cooking. It was the kind of thing where if the country is looking at sending a child back and can use its usual domestic standards, best interest, what the countries found was that the child was never going back. Because it was one of those things of, well, the child ought to remain in my country because my country is far superior to fill in the blank. And it didn't matter who you were asking the question to. So the way to avoid that home cooking, these nations thought, was to take best interest completely out of it. And with rare exception that it's actually not supposed to feature into best interest, those things occur. Just a jurisdictional test. And the cornerstone of all that is habitual residence. Where has this child remained for a sufficient period of time? There's a year litmus test in there where if the child's been there for less than a year, it's mandatory return, again, with certain exceptions coming from Article 13. If it's more than a year of time, then the judge has the discretion to decide whether or not the child's well settled. So it really is a jurisdictional test. In our particular case, well, let me talk about how we got there, first of all. So I'm going to turn something. As you were hearing, we practice family law, and we have 10 attorneys. We have 6 offices around Georgia. Most of them are around the metropolitan area. One of them is not, it's in Savannah. And so we're in trial court, our attorneys 3 to 4 times a week, each attorney, because it's a pretty busy practice, and I think the only people who go to court more often than family lawyers might be prosecutors. And so we have a whole number of hearings. I fell into international practice about 12 years ago, thanks to an uncontested divorce. A fellow came in and saw me. He said, well, my wife and I have talked about getting a divorce. We agreed to all the terms, just need you to draw it up. Sure, signed them on for like a $500 retainer back in the day, I'm sure. And he told me what the terms were. By the time he left, let me get that. Come in. That's a different door. By the time he left our office, he had everything he needed. I didn't hear from him. Until about 3 months, maybe 4 months later, I'm watching the evening news, and this picture pops up on the news as an international fugitive that has been captured in Mapleton by federal marshals. And so I went down to talk to him, where he was held in federal custody. Here's what happened. He went home, he said, honey, I consulted with an attorney, They've drafted everything up. It's right along the lines of what we talked about. Please read it. He says, read it. If you've got any questions, give him a call. Sign it. We can get divorced in 31 days after we get this thing filed. And she said, that's a wonderful gift. Thank you very much, because she's French. But first, let me go home to see my family. I'll take the children. We'll be gone for a month. We'll be back. 1 month stretched into 2, 2 stretched into 3. He went over to France to see what's going on. Turns out she was sleeping with every man and woman in the little town in France. Taking umbrage with that, he took the children to Paris, flew home, enrolled them back in their school in Mableton. She claimed he kidnapped the children. She admitted she was married to him and said, this is not the children's father, which got the French government all up in arms, which got our government all up in arms, which resulted in him being arrested, taken down by federal marshals as he was taking the children to school one morning. And that's how we got involved in our first international custody case. From that, we were able to keep him from being extradited, thanks to the help of the U.S. Attorney's Office agreeing not to appeal the case, should the trial judge agree not to extradite him, and with the help of the trial judge, who saw the merits of the argument and allowed him to get out on his own cognizance on an extradition case. With that going on, another important part of that, while he was in custody, their children were now deprived, right? Because the mom was over in France, dad's in federal custody. So under that condition, mom comes over here and she's picked up at the airport by the French consulate. French consulate shows up in juvenile court with her, and our guy's in custody. We say, well, why don't you use the house while we're trying to work through this? They say, great, we'll stay in the house. And the French consulate swore to the juvenile court judge, she'll stay in the house, everything will be fine, we'll be able to go through this and go through the divorce and get all this straightened out. Not so. They loaded the children, they loaded the mom into the limousine for the French government, immediately to Hartsfield, where the French government had bought them tickets directly back to France. And thus began the international incident that was the Hague case for our point of view. So we were able to get in custody through Judge Ingram. And part of what you do in family law is you tell your client, go look through everything in the house. One of the things he found in the attic was where mom had all along contended she didn't know who these children's father was, the French government, and therefore was able to get French assistance, which she kept in an unnumbered Swiss bank account, which would have worked fine if she hadn't left all the documents in the attic. The other thing we always say to do in family law is record your conversations. So now we're working through all this, and we got custody, but during the course of the conversation with her on the phone one night, he says, you broke my heart. When I came to France and I saw you were sleeping with every man and woman in this little French town, you just broke my heart. Why did you do that? And her words were classic, and thanks to him reported for all posterity, particularly the French public, she said, well, what do you expect? I'm French. The French government now thought they really didn't want to help her out very much. So we went to France and tried the criminal case on international kidnapping, which we won because he was his father. And then their version of the Hague, the equivalent over there, which we won, came back. We're now 12 years later. The kids have graduated high school in Cobb County. They're gone to college. One of them's graduated. And mom and dad have renewed their relationship, and the children actually visit her in France when they want to. So that's how we got into it in the first place. Since that time, about 100% of my practice has been devoted to international family law, though we still handle divorces and this stuff, about the rest of it. In our case, there's our reason for being. Eris, beautiful little girl. Long story short, mom and dad met each other in Germany. She's Scottish, he's American. He was stationed over there. Fell in love, got married, very tempestuous relationship. Had Eris. Now, long after she was born, he got deployed to Afghanistan. 15 months. And so mom did what often happens when soldiers get deployed and they're away from home. I want to go home while you're gone. I said, okay, sure. Her home was Scotland. So she and Eris went home to Scotland and maintained a relationship by mail and other communications with Jeff while they were gone. He is a sergeant first class. Oop, I'm wrong way. The United States Army. He diffuses bombs for a living. He's an interesting fellow to know. He's the coolest, calmest guy you'd ever want to meet, because think about what he does. So he's in Afghanistan for 15 months. He comes out, he gets deployed to Redstone Arsenal, right outside of Huntsville. And he writes emails to his wife, I'm going to re-sign up, I've got this huge bonus, how about we buy a house here in Huntsville? She goes, a little on again, off again. Some emails are, I love you, I can't wait. Some emails are saying, I'm not so sure we get along. Okay, fine. She comes over, they pick out a house, she's remodeling it, she's redecorating it. They have a little bit of a fight while they're doing that, she takes off again. Okay. Now we're into November 2009, and she's saying, okay, we're going to make this work. I'm on board, hook, line, and sinker, 100%. All of her emails, all of her Facebook posts, even down to asking the United States Army to move, according to her language, all of my worldly possessions from where she had it in Scotland to their home in Huntsville. And so she comes over to Huntsville with Eris, and interesting the way that goes, lands on Valentine's Day in 2010. And again, the relationship is on again, off again. Sometimes they're in great shape, sometimes they're not. Third one time in May, when they're not, she does something else which is not atypical. In an argument, she says, "I'll leave and you'll never see our daughter again." Of course, in this context, it has additional implications. He panics, hires a divorce attorney. They file for divorce, ask for an emergency hearing. By the emergency hearing 1 week later, we're back in honeymoon phase. They go in front of the judge and they say, "There's nothing here to see. We're all getting along great." And the judge says, "Go forth and sin no more." Right? They don't dismiss the divorce, but there's no order that stems from that. The divorce winds on through the summer. They have a calendar come up in September, which they get off of. They have a calendar coming up in December, and I'll talk about that. But during this time, Mom has a terrible alcohol problem. And while this is the interesting thing about our trial, we had something like 8 witnesses testify. Seven of them were officially for us. One of them was Mom. She testified for us too. And here's an example of that. She would say, "Yes, while I was out getting drunk with my friends, he was home putting our baby to bed." Right? She was very good in the sense of, he's a good man, he's a good daddy, he cares about this child, right? The only thing she did say is that when she winds up back in Scotland, she thought the girl ought to be with her. So now we're coming into December of 2010, and for that calendar, she actually hires counsel who requests that that case be continued. She didn't want to see a judge, neither one of them did at that time. She didn't want to see a judge. Unfortunately, because of this drinking problem, she gets twice picked up by the authorities because she's wandering around drunk. She tries to take a cab home. I think what happens is they can't understand her, as drunk as she is, and with a Scottish accent. She literally beats up 2 cab drivers. She tries to beat up 2 cops in 2 separate instances, and Jeff gets her out of jail. But on Christmas Eve, he wakes up to find her standing over him with a knife in her hand, saying, "You'll never leave this room alive." Now, she doesn't say that occurred. What she does say occurred is that she was well into her second bottle of wine when the police showed up, and she didn't know why. But at any event, they take her in on family violence. The local authorities have had enough of her, they contact ICE because she's overstayed her visa. She's overstayed her visa, but at the same time, she's been applying for she's been applying for a green card here. She's 1 week away from that meeting from having her green card. So she's petitioned for permanent residence. They take her in, they hold her for deportation, they deport her in February. The first time she ever says, "My child should be in Scotland," is the day after she lands back in Scotland. Up until that time, everybody, and she testifies to this, everybody she wrote to, everybody she talked to, she described the United States as being where they lived. Therefore, this child's habitual residence. She's now filed her Hague application. They're coming up for trial, and their contention is, this is a dual citizen child. She has a British passport, she has a U.S. passport. Remember going back to May when they had their argument, he took both passports in abundance of caution. According to Mom, only one passport, the U.S. passport, turned up back in the family safe, the same place where she kept her own passport and other important papers. She testified, Mom testified, she could have taken this child back to Scotland on the U.S. passport anytime she wanted to, but it would have been inconvenient. All right, so these are the facts that we have in the trial going on. We had our trial, like I say, absolutely everybody testified for us, including Mom, but still Judge Ingrid Pritz-Johnson decided this child should be returned. And she premised it upon the passports, which she said plural. The passports were missing. There's no fact in the record. This is the passports. It's very clear what Mom testified to. We're missing. And so at the end of our trial, the judge announces this from the bench, right there. Within 20 minutes, having a sense this was coming, we started at lunch working on our motion to stay. We filed our stay, written motion to stay. Within 16 minutes, she issues a written order saying no stay granted, and gives Mom license to leave. Our client had literally 20 minutes in the parking lot with his daughter to say goodbye. And the reason why all that happened is because she was catching the very first flight out of Huntsville that was international, happened to be to Canada. And the reason why they wanted to do that was because of the Bakir rule. The opposing counsel well knew. The Bakir rule. Opposing counsel well knew that under the 11th Circuit rules, precedent, when a child leaves our borders, our courts are powerless to do anything about it. We lose all jurisdiction over those children. So their premise was, rightly so, that if they can get her out of national airspace, it was over. It was all done. We went ahead and filed our appeal to the 11th Circuit. The 11th Circuit came back with the Bakir rule and literally says we're powerless to do anything about that. Hence, we went to the Supreme Court. There's a split in circuits. A majority of circuits that have ruled on this issue have found that the 11th Circuit makes no sense in its statement that it's powerless to do anything about that the case has become moot just because a child's been removed from our borders. So we filed our petition. I had filed one before and hadn't been successful under Furness versus Reeves. That was 2004. In 2010, the court resolved that split in the circuits under the Abbott case, which was the very first Hague case taken up by the Supreme Court. So they allowed that issue to fester for 6 years before they resolved the split in circuits. So I didn't have much of any expectation that it would work, but it did. One day in August, I'm out and about, get a call on my cell phone, and it's the Supreme Court saying, "We're taking your case up." So, after I pick myself up off the floor and immediately get back to the office, the phone is absolutely lighting up with everybody in the world, press, other firms from Washington and from New York, asking if they can take the case. They'll take the case for free. They'll devote as much as $1 million of attorney time for free. And of course, as somebody who owns his own business, first thing I hear when we'll donate $1 million worth of attorney time for free, I'm thinking, it's worth that to you? How can I hang on to this case? How can we do that? I think that the Supreme Court took the case up because we had been pending about a month or so before they took it up. But just a week before they took it up, the Fifth Circuit, who hadn't yet ruled on the Bakir issue, under a case called Larby versus Larby, another service member case that has to do with a colonel in the Air Force. And his wife had taken off to England during the course of a divorce case. And so the trial court on that case said, well, she's gone, we don't have to worry about this, she needs to stay in England. The Fifth Circuit just absolutely excoriated the 11th Circuit's decision in Bakir. And that really made that split in circuits just visceral. And so I think that's why the Supreme Court took that moment to take it up. In talking to these big firms about hanging on to the case, and the word got out there that nobody else was going to be stepping onto the case with us, the press started contacting us in ever-increasing furor. And this was kind of the overall take, that for this little firm, and while we're 10 attorneys from a bigger standpoint, that's a small firm. A little firm going all to the Supreme Court, we must be full of hubris to do that. And that was an interesting place to be coming from. But we soldiered through that, and we could not, frankly, have done it, I think, alone without putting together an excellent team, including the other attorneys in my firm who worked an awful lot with me. We had an awful lot of help, and I want to give a nod out to University of Pennsylvania to a great extent, who helped us write that brief, who prepared me in a moot, and for all of the work that people poured into getting me ready, I couldn't have done it without just man hours of pounding me down to salt and restoring me after that. Part of what we all did together was amicus sales pitches. We went around to different groups, the two that we went to, National Center for Missing and Exploited Children, and they were very much on board. Of course, they had a record from the Abbott case, so we knew they were going to come in on that. And also, probably particularly key was the pitch that we made to the U.S. Attorney's Office, the AG's office. And the way that works is that we go in, we make our pitch, and it's the whole dog and pony show. You think it was straight out of admin or something. Here's what we think our case is about. And then they go, thank you very much. We leave the room, and there's our opposition waiting in the green room, right? And they come on, and they make their pitch. So when the U.S. Attorney's Office said they were going to be on board, that kind of made an entire paradigm shift about how I thought we could handle the case. Because, of course, our argument to the U.S. Attorney's Office is the Bakir rule is so broad, it isn't limited to the Hague. What they're saying is that if we think about the child as the res, anytime that the res is gone from our country, we lose control over it. What about criminal extradition cases? Right? We lose control over that. What about cases against foreign governments? We have orders against governments from time to time. They aren't in our jurisdiction. What about cases that have to do with property talk about unnumbered Swiss bank accounts in foreign countries. We wouldn't have any control over that if the Bakir rule became the rule of the land. And so the AG's office saw the merit of that. In preparing the brief and preparing the reply brief and in the moots, we had 3 moots. The first was at Georgia State University, my alma mater, and that had a lot to do with the philosophy that we wound up adopting in our approach and oral argument. The second was at the University of Pennsylvania. That was probably the most grueling of briefs because they were the ones that helped us prepare the brief. They were defending our brief. They knew more about it than anybody else. And in the Georgetown brief, which was the Friday before Wednesday's oral argument, and that brief was particularly notable because of all the celebrities that were on the panel there. There were people that had worked on Hague. There was a lady who argued Abbott. It was a real wonderful opportunity to get to meet her. And so that was, and a gallery full of people, onlookers and well-wishers. In terms of preparing the brief, it was interesting to watch the process of going from a briefing book, which was just mammoth, and thinking about, I need to know all this, pare it down to the work that, as I began to scale it back to, I think it was 16 pages at one point of stuff I really thought I was going to take up and have at the lectern before me, down to 6 pages, and finally what I took up with me was 2 pages, and I didn't wind up looking at any of those. But I was talking about the Georgia State moot and how that impacted things. There were 2 intentional decisions that we made: philosophy of content, philosophy of delivery. The philosophy of content stemmed from Professor Siegel's book about Supreme Court, arguing that the court is a political body as much as anything. And what they're interested in is policy. What are the implications here? That's part of their job. And so an important focus of our argument was what are the implications of a decision that goes the other way and the implications of a decision that goes our way. Philosophy of delivery took a lot of work to convince everybody to get on board, and I'm not sure we ever did. The prevailing view was you want to argue with the justices. You have your agenda. They're going to ask you questions that you will think to be inane. Get them off those questions and get right back on board. Argue your agenda. Stay. Pound, pound, pound. And I thought that was probably not the best approach to take. Probably in part because we had the AG's office to be able to argue some of the issues, but also in part because my take on these justices were, you know, they put in the long hours, they went to the trouble of knowing what the case was about to grant the petition, and for the brief time that I had in front of them, my job was to answer the questions. You know, I wanted to hear where they were coming from, because my bet was by the time the argument came up, they had a pretty good idea how they were going to rule it. They just had a couple of things they wanted to resolve. And if I took them off of their agenda, I was not going to satisfy what they needed to know. So got a lot of flack from that, in not wanting to argue with the justices, not wanting to pull them off of where they wanted to stay. It was an interesting time in D.C. Like I said, we arrived on Thursday for the Georgetown moot and stayed there through the Wednesday argument. I hadn't realized how in tune D.C. was with its court. By that time, we'd been on CNN, Fox, and ABC, I think, and it was just incredible the number of people walking down the road that knew not only me, but knew what my case was about. And could talk to me intelligently about the case. Couldn't ride in the cab without the cab driver saying, "Hey, you got that case coming up." And you'd have it on the radio, and you'd hear them talking about our case. It was just, and next week in front of the United States Supreme Court, these are the cases they're taking on, and they had intelligent discussions about that. We're not ready for that. A lot of people have asked me about, was there a lot of pressure going before the United States Supreme Court, and I'd say, no, not really. I decided about October. I decided that if I let the pressure get to me, it was going to be overwhelming and there wasn't going to be anything left of me. So it was quite an intentional act, probably against every single psychiatrist and psychologist with advice that they would give it to me. I just repressed absolutely everything. And as my wife can tell you, much to her chagrin, let it all hang out after the Wednesday argument. And I had my nerves. I saved it until like a month, the entire month after the oral argument. That was my nervous breakdown time. It certainly was an emotional roller coaster to think about all that was hanging on this argument and all of the people that were looking for us to be successful with that. You know, my sense of the way, and you watch a case develop, reading the briefs, our briefs, their briefs, that we were abundantly right. It was going to be odd for the Supreme Court of the United States to say that our position was wrong. It was going to be odd from a policy standpoint for the United States Supreme Court to say that we shouldn't retain jurisdiction over our children when they're taken from our borders. So knowing that all of this was going in our direction, I could still quite possibly mess it up. That was pretty tough. So the day of, I hear the argument on Monday, I hear the argument on Tuesday, which was recommended to me by the Georgetown folks. The day of, going into that courtroom, and y'all probably all been there, you know how beautiful it is. It's just absolutely gorgeous. It's everything you hope it would be. The bailiffs in the morning coats, I'd take a little story about that. I went up there with my wife and my 10-year-old, and they let them come on up to the briefing room, on up to the attorney's room, and that was quite a treat for them. And the tallest of all bailiffs looks down at my son and said, "So are you ready for your argument?" He goes, "No." He said, "We better get you ready then." He proceeds to give him nice stuff and treat him very well. Justice Roberts wanted to make sure he had my name pronounced right, so he sent one of the bailiffs in to just make sure that they got all that right. It was very nice. And of course, we walk into the courtroom and the gallery's full, and your quill is sitting right there. It's like, this is really cool, it's amazing. And they point out the lectern to you, so yeah, you can roll it up and make it come closer. I can see, oh yeah, I'm gonna roll it up, and there go the papers, right? No, I'm not touching the lectern. The lectern stays where it is. And then when the case is called, of course, they come in and they sit, and the case is called. You know, by then I'd seen the courtroom Monday and Tuesday, sat with it for a little while on Wednesdays, waiting for the justice to come in. What I hadn't been aware of is how intimate the court is. For as big, as beautiful, and as grand as it is, to walk up to the lectern and be as close as I am to the camera here to Justice Roberts. And in your entire periphery are the justices, and that's all you see. And except for the fact that you're standing, it's very much like having a conversation in the living room. You know, you're just having coffee and discussing important issues with these people. And my sense of them was that they were committed, they were compassionate, they cared, they knew intimately everything about the case that they possibly could. It was very heartening to have that happen. The game plan, the strategy was, I was going to talk to Justice Thomas first, just stay right in, talk with him, because he's from Savannah. And by then, our guy had been stationed to Savannah, so we were getting a lot of press out of Savannah. His mom still works in Savannah, and because he's the least likely one to ask me a question. So I figured, just focus right there, and we'll be all right. And I proceed with what I started talking about. See if this works.
We'll hear argument this morning in case 11-1347, Chafin versus Chafin. Mr. Manini.
Mr. Chief Justice, and may it please the court, United States courts have the power to effectuate relief in the Hague Convention cases under circumstances presented here in this international treaty. Sergeant First Class Chafin's appeal from the district court's decision is not moot, because reversal of district court's judgment could grant Sergeant Chafin relief in 3 ways, each
sufficient to preclude mootness. I'm not as good at PowerPoint. You can tell I was awfully nervous, but Sergeant, who's my client? Chafin. Yeah, that's right, Chafin. I promise I won't play all 30 minutes, all hour of the argument. These are just excerpts.
First, a reversal would mean that the United States is the child's habitual residence.
I don't know why that ended. Second, the way you can read is going on to the argument. By the time I get down to the bottom here, I had about 45 seconds of prepared text, because we all know they jump in there, right? But by the time I'm getting to about here, I'm starting to panic, because nobody's asked a question yet. And I'm looking at the end of my, it's like, you know, what do I do when I get here? Uh-oh. Oh, okay, I'm sorry. We're going to take a bit of a detour. I've already passed that. Okay, let's see if we can get audio again. It's going to be a challenge on the audio. I apologize for that. I'm thinking about how we're going to handle it without the audio. Having Justice Scalia, he wasn't the first one that chimed in, so I recall it would have been Justice Thomas. But Justice Scalia was particularly interesting because of his tone of voice. He goes, well, that's just bad law. And I don't know how many times, probably 3 times during the course of the argument, both with me and opposing counsel, his response would be, well, that's lovely, but, which has now become a phrase around the table at our house. That's lovely, but. And the other interesting thing is that we know these justices. We've spent time with these justices in the opinions that we read. And so we think we have a sense of who they are. And I was prepared on who I was going to have my battles with. Justice Ginsburg is really the one that battled with me the most, which thoroughly surprised me. She was just absolutely on this issue of, from a custodial standpoint, should we have binational custody cases going and how hard that could be on the kids. So I think we'll move through these a little faster then. My opposing counsel is from Scotland. And sorry you guys won't get a chance to hear his accent. But Justice Sotomayor, who of course was the expert on the bench for Hague cases, she'd done a lot of work on the Court of Appeals on Hague, they tended to look to her to kind of give them a direction of where they were going to go. You can see that changing now with Justice Roberts writing our opinion. You see she's asking, why can't she come back? Because we do have jurisdiction over the mother, don't we? I mean, we're still here. And his response was, no, they can't. They absolutely cannot. You think Scotty, right? I can't get him for his movement, Scott. No, they cannot. So that was fun in the courtroom. And what's going on here is Justice Kennedy's talking about the text of the convention, and forthwith becomes an important word for Stephen to talk about. It means right now. Time and again, the treaty tells us you must act expeditiously. Because the idea of Justice Kennedy is we avoid competing litigation in countries. We must have one country that's deciding this. And there's Justice Scalia. So you're arguing that the effect of the statute implementing the treaty, which uses forthwith in all this, is to in effect require that unless there is a motion for stay pending the decision of the trial court be carried out. It was yes, Justice Scalia. He says, you think the mere word forthwith in the statute is enough to alter our normal process of appeal? Stephen and I see each other quite often in Hague cases. Our firm is the only firm in the Southeast that does this work all the time. The next closest firm is his in Baltimore. And the word forthwith has kind of become a running gag with us. I don't think we have a letter going back and forth anymore that doesn't have the word forthwith somewhere in it. So. And Justice Kagan, now you know you're in trouble on an appellate argument when the Supreme Court Justice says, I'm trying to figure out exactly what your argument is. So let me give you two options. You tell me which it is. And she's setting up the two options. And down there at the bottom, you'll see Mr. Cullen respond, I'm going to take a third non-offered offer. It's neither of the two you thought it might possibly be. Okay. All right. So you know you're in trouble then. Of course, I'm sitting right next to him here in front of the bench and just enjoying it a fair bit at this point. So we're talking about the terms of the convention. Justice Alito, your proposition that under the convention, once the child has left the country, a U.S. court no longer has any power to order the child to come back. Yes, Justice Alito. And I don't see where that was decided, either by the court in this case, or the Beck-Here case, or the 11th Circuit panel here cited. There's no discussion in either of those opinions of how the convention says on this question. And Beck-Here literally says we're powerless to do anything about it. It doesn't say how that enters into it, why we're powerless to do anything about it, unless you allow that the res is not here, so our words would be worthless. And when you enter into the whole argument about it doesn't have to be complete relief, we contend it can be complete relief. We contend that it is error for us to assume that the British Empire will thumb its nose at a convention to which it is signed, right? That if our court, following the power requested of it by the plaintiff in this case, the Scottish resident, to see this case through, that if our court sees this case through and says the child come back here, which is exactly what they did in Larby, that the Scottish court wouldn't say, you go back. So I think it's error to say the British Empire will ignore us completely, which is Cullen's argument. But even not just withstanding that, there's the whole argument about costs. You guys may have read that they were allowed $94,000 in costs on this. There's a provision in ICARA, which is the implementing statute for the Hague Convention, which you could read it to say it's mandatory, the cost be imposed, but actually there's discretionary language that says, unless it's unreasonable or something to that effect, the word escapes me. There's a brand new case out of district court from, I want to say May, which is the first chink in that armor, which says I'm going to apply discretion here and decide that I don't have to impose all the fees. But the judge hammered Sergeant Chafin with $94,000 in fees. And so there's a question about, all right, if we reverse the trial court, we obliterate the fees. Isn't that grounds enough to declare that the case is not moot? And so that's what's going on here. And so we come back down to Justice Alito saying this is not a question about our general standard of mootness. It's a question of meaning of the convention, which goes back to Kagan's question about what you're arguing about in the first place. As I understood your argument to Justice Kagan, your position is dependent on a particular interpretation of the convention, and I don't see any discussion of that interpretive issue in either of those opinions. All right, this is the last slide that you guys won't get to hear, unfortunately. So Mr. Cullen finishes as he sits down, and Justice Roberts tells me I have 4 minutes remaining. I start, and I do the typical point. I got 4 points, so everybody's listening for the 4 points, right? I get through the first one, and what I really learned from this is that in 4 minutes, you can spend 4 minutes with one question coming from Justice Breyer, one question coming from Justice Ginsburg, and you have no response whatsoever. So I'm watching Justice Ginsburg and watching Justice Breyer, and I'm watching my clock and I'm going, my time's over. That's it, we're done. Okay, thank you. So we finish with the argument, the justices leave the room, and there's pandemonium breaks out behind you. Everybody's just elated that this has gone through. And remember, this is December 5th, 2013, last day of the term, last case to be heard. We were only case on Wednesday. So everybody was relieved that it was over for the Christmas holiday. We're done. And all the folks behind us and start gathering their breath and all that. And now comes the very predictable, for this room, wait for the opinion. And how long is that going to take place? And that did not take place. That did not take very long at all. One very important feature of the Hague Convention is we try to do things very quickly. There's a 6-week optimistic timeline that the convention applies. Try to get it started and finished within 6 weeks. Generally speaking, until now, we've interpreted those 6 weeks as meaning within the trial, but there's some pressure to try to interpret that within the appellate level too. I don't think that's doable. I think trial is certainly doable. And I think under the standards that the Supreme Court set for the analysis of stay, which doesn't change anything, by the way. Stay is still the same. That's what we were arguing. Use our existing analysis for stay, apply it to here, then we can handle the appellate level on something other than a 6-week time frame. But the court is very sensitive to trying to get things done even on the appellate level. And on February 19th, just a few months later, we got a decision, and I know. We had thought, optimistically at one moment when we were looking at how the case was setting out, that it was possibly a kumbaya moment for the Supreme Court. But I thought, oh, that's just being silly. Maybe 7-2, maybe 6-3, but it was a kumbaya moment for the Supreme Court. Complete with a concurrence by, right, Justice Ginsburg, Justice Scalia, Justice Breyer. It was just an amazing time. The court held that a return of a child to a foreign country pursuant to a convention return order does not render an appeal of that order moot. Manipulating constitutional doctrine and holding these cases moot is not necessary to achieve the ends of the convention in ICARA, and may undermine the treaty's goals and harm the children meant to be protected. So, unanimous decision. It was absolutely amazing. The cost to the firm in doing this, I talked about them offering $1 million in free attorney time. I would say, and we didn't certainly keep up with all of our billing, but we lost probably about $150,000 in attorney time we sunk into that. And for our firm, that was a chunk, and it took a while for us to recover. I think we're safely out of the woods again from that, and our vendors were all very kind to us and supporting the military. It's really what we were doing in getting through that. And about $25,000 in out-of-pocket costs in getting everything accomplished. The benefits in doing that? First one, I get some trouble, which is really cool. Obviously, I have the penultimate experience in my legal career. And suddenly when I talk to people, they think I know what I'm talking about, which is really, really, really neat. The rest of it is still to be determined. We'll see how that plays out over time. But it's been quite a ride. I would say that the analysis for all of us is that if I can do it, y'all know you can do it, right? This gets done. And to me, we think about where our peculiar role is. Third branch of government, a co-equal branch with the executive and legislative. This is the three-legged stool that makes democracy work. And so for my, if I can speak very broadly, rags to riches story, right? From the lowly trial lawyer out of Marietta, all the way to Supreme Court, isn't this a testament to our country working? Isn't this a testament to this? This is something that makes it all happen the way it's supposed to happen. It gives access to justice, which is the underpinning of our democracy, because this is our court, after all. Final analysis for children, U.S. children everywhere, is that whether they know it or not, they can sleep a little bit easier at night. Because if their parent, usually it's a foreign-born parent, but not always, if their parent is having a hard time with their spouse and they decide to up and leave and go home, and home happens to be, fill in the blank, some other nation, our court still has jurisdiction over it. And this would have impacted us significantly because there are a number of divorces that take place while the parent's abroad with the child. And so that would have deprived our Superior Court of the ability to make jurisdictional decisions about that child that's now been abducted, right? So we can continue that work. Final analysis for Sergeant Chafin and for Eris. Well, the Supreme Court said, importantly, whether at the district or appellate court level, courts can and should take steps to decide these cases as expeditiously as possible for the sake of the children who find themselves in such an unfortunate situation. Expedition will help minimize the extent to which uncertainty adds to the challenges confronting both parents and child. And in Justice Ginsburg's concurrence, she says, on remand, the court rightly instructs the Court of Appeals should decide the case as expeditiously as possible. We filed our brief back with the original brief, and they accepted it as the brief, and that was way back before we went to the Supreme Court. So, very quickly, the 11th Circuit said, other side, we want you to file your response brief within 30 days. That's been done. File your reply brief within 15 days. That's been done. All briefs have been in since the end of April, beginning of May. And we have been waiting for an argument to be, well, actually, both sides said we don't need an oral argument. But yesterday, they gave us a date of November 18th. November 18th. You know, it's hard to argue that as citizens we should follow the rule of law when we're looking at as expeditiously as possible. Should decide as expeditiously as possible. I don't think that November 18th is as expeditiously as possible. And I don't think I'm wrong in that reading based upon what Justice Ginsburg, Scalia, and Breyer have said emphatically in their opinion. So I'll leave it to this room what to do next. Is it mandamus? Is there some other remedy? I'm open to suggestions. On a side note, procedural note, a very interesting development out of this. As you may know, under the UCCJEA, courts from different states talk to each other all the time under that framework. In this case, for the first time, according to the justices ever, the High Court of Britain conferred with the United States Supreme Court. And it was an amazing moment. It had to do with the Chafin case, but it had to do with what they were doing with the Chafin case, with the Lardy case, which we've been involved with over there. And so we now have very high-level courts communicating with each other and trying to see, there's no framework for that. How does that work out in our system? But ultimately, so what's next for Sergeant Chafin and Eris? She's still held up in Scotland. He still gets to see her on a fairly regular basis. He and his still wife, they're still married, still going through the divorce in Alabama. We've held that up as long as we possibly could. If you had asked me before this time yesterday, I would say we're going to have an order from the 11th Circuit very soon. I had predicted the end of May at one point. And we'll be trying the case in Scotland in July. Now, absent something which really moves up that November 18th date, I'm not sure. Because it seems to me that it's kind of being projected from the 11th Circuit that this little girl isn't quite as important as the Supreme Court thought she was. Anyway, so I ended on a bummer note, right? But thank you very, very much for asking me to be here, for granting me the audience and the time to listen to me. Let me tell you the great story about Chafin versus Chafin. Any questions?
I have a suggestion.
Yes.
I had an email from somebody yesterday that I wrote the brief on, and the 11th Circuit was trying to move an oral argument to, I think it was July 24th. And I was going to be out of town, so I was like, oh, bummer. And then I got another email that said the U.S. Attorney's Office can't make it. So that July 24th date might work, so you might want to call the lady's name is Joyce Pope.
Joyce Pope. Okay, I will do that.
Maybe you can have that date.
I will do that. And my bet is the opposing counsel would agree with that outcome as well.
Yeah.
All right. Anything else? Thank you very much.